Good morning. I want to talk to you today about guardianship clauses and guardianships in general. New parents, parents of young children, parents of teenagers all need to consider what will happen in the event that, that the parent dies and the children are left to be raised by somebody else. Well, a guardianship clause within a will and a temporary guardianship document can create a level of peace of mind that ensuring that if a child has to be raised by somebody else, that child will be raised in the manner that you, the parent, want. Guardianship clauses generally are included in wills, and the need for a guardian arises when a parent dies, or when the second parent dies in a two-parent family. In that situation, when a guardianship person is named, when a guardian is named, then the child will go and live with that person, and that person will raise them. In effect, acting as if a parent. This has a twofold kind of benefit. One is it creates peace of mind, basically. In one sense, you can be assured that by naming a guardian, that your child is going to be raised in the way that you want. Second, you're going to eliminate the possibility of conflict. Courts weigh guardianship clauses very heavily. They want to carry out the dictates of the parent. They want to make sure that the desires of a parent or parents is carried out in the event if a person dies. So by naming a guardian, you can give yourself the peace of mind that you know that a child will be raised by a loving friend or family member that you want. The second way you can protect the child is through a standby guardianship. This gives a named guardian the right to act as a child's parent in the absence or incapacitation of the legal parent or guardian. Okay, it does not take away the rights of a parent. Rather, it provides a standby guardian the same rights as the parent. It offers the parent flexibility because it allows the parent to name a termination date, and it can be done through writing if certain formalities are observed. So it's a document that can come into existence right away, so that if in the case of two parents who go out to dinner and something terrible happens to them, and the children need to be taken care of, there's a standby guardianship in place so that somebody can be contacted immediately and they can look after the children until such time that the parents either recover or it becomes apparent that a permanent guardian needs to be named. Temporary guardianship documents generally give a person 60 days before the permission of a court is required to continue that guardianship. 60 days, or in the instance of the death of the parents. Finally, if a parent will be out of the country or away on an extended trip, they might also use something called a designation of person in parental relation as a method of ensuring that a competent adult has the authority to make decisions related to a child's school or health while the parent is away. The use of a HIPAA authorization in conjunction with these designations and with a standby guardianship should be considered really as a very, very effective way to making sure that your children's needs are taken care of in your absence. These guardianship documents can be used in conjunction with other estate planning documents to provide for as many contingencies as you can imagine. Okay, they're effective, they're recognized by courts, and they can be drafted with the help of your attorney. I cannot emphasize enough how important these documents are in, one, ensuring that your children are looked after in the event of your death, and two, that your children will be protected in the event of your incapacity by utilizing a temporary guardianship or a standby guardianship document and the guardianship clause in your will. You will generate peace of mind that you desire and the safety of your children. Thank you very much.